Good evening and welcome to the continuation. My name is Tapiwa Zivira and I'm your host tonight. Tonight, we're discussing the shocking surge in cases of child sexual abuse. Statistics are showing that in the past 6 months alone in Zimbabwe, 680 minors have been impregnated. To help us with the discussion, we have two prominent human rights lawyers, Isheanesu Chirisa, the Director of Women and Law in Southern Africa, and Rufaro Deshe from the Legal Resources Foundation. We'll start off with Rufaro. What is your quick reaction to this? How did we get where we are?
Hi Tapiwa, thank you so much for having me. My name is Rufaro Deshe. I'm a lawyer with the Legal Resources Foundation. So yes, my quick reaction to this matter is that indeed there is a statutory instrument which was brought to life by the Presidential Emergency Decree for the protection of children and young persons against sexual exploitation. And this decree was necessitated by the implementation of the Constitutional Court judgment in the Kawenda versus Minister of Justice and others case. So what happened in this judgment is that the Constitutional Court ruled that a child is any person who is under the age of 18 and therefore declared unconstitutional any provision of the law, particularly the Criminal Law Codification and Reform Act, which says otherwise. So the Criminal Law Code gives a definition of what it terms young persons as people between the ages of 0 to 16 years. And yet the Constitution says a child is the person between below the age of 18. So there was that discrepancy there, and there was that inconsistency, which is what the Kawenda judgment then sought to remedy in order to protect children against sexual exploitation. Because what that meant was that there is a group of children that were not necessarily protected by the law, that is children between the ages of 17 and 18. So what this judgment then did is that it declared these provisions unconstitutional, and it then gave legislators a period of 12 months to prepare and amend those laws so that they speak to what the Constitution said. So what then happened again is that the 12 months period expired. After this 12 months period expired, it means that there's no law that was in effect. So there are crimes such as having sexual intercourse with a minor, which then would go unpunished because at the end of the day, they were not provided for under the law. So for a period of time, there was no law in effect. And it's not surprising that as part of those 680 minors that the Herald reported to have been impregnated, most of the perpetrators were actually not brought to book. So from the period of the 25th of May last year up to the 12th of January this year, there was no law in effect until the SI was then put in place. The SI now, the statutory instrument, can only be in effect for a period of 6 months, which is the period that is expiring in July. And we're at risk here of the same thing happening, us facing the same situation where again children are not protected. There's no law that is necessarily protecting them. So we're at risk of having children who have been exploited, who have been sexually exploited, failing to get recourse from the law, and perpetrators again then moving around without being punished. So currently the Parliament, there's a bill, the Protection of Children and Young Persons Bill, and suffice to mention is that there hasn't been significant process in terms of a process where this bill is then eventually enacted into a law. We're talking of July, which is next month, and this hasn't been done as yet. No public consultations have been held and all of that. So there then becomes a problem there. But obviously Parliament has the power to then suspend some of its own processes. So we hope maybe that this bill is fast-tracked and that by July or by end of July, we have a bill in effect which is protecting young persons. Because if that is not done, then we go back again to laws which are not applicable because they've been declared unconstitutional by the Constitutional Court. But outside of that, while Zimbabwe, yes, has an international obligation to enact laws that protect children, and the lapse of the SI will cause serious problems. We should also, I think, go beyond the law. We need more social protection measures to ensure that children are protected. According to the Dakar Declaration of 2000, states, including Zimbabwe, have an obligation to allocate at least 20% of their budgets to education. And recently, in 2024, the education budget is around 17.7%. And does this ensure that children remain in school and they get comprehensive sexual reproductive health rights education so that they are also able to protect themselves? They know how they distinguish when something wrong has been done to them, and how they can also protect themselves, and how society can protect them as well. So that would be my quick reaction to that. Thank you so much.
Thank you so much, Rufaro, for giving us that comprehensive background and also your own analysis of the situation. We move on to Isheanesu. What does this mean? Is this a legal problem? Is it a social problem? And what are the mitigation strategies that we can use as a country? Over to you, Isheanesu.
Thank you, Tapiwa. I think, just as I said, that the problem is both legal and social. It means it requires both legal interventions and social interventions. We may then need to question our values as a society. We may also need to question our legal enforcement mechanisms. How sufficient are they to protect young girls from sexual abuse? And do we have adequate reporting platforms, especially where sexual abuse would have taken place within the family setup, as I have alluded to earlier on, that often such abuse is underreported. And then at community levels, do we have social protection units which then instill the necessary values within the community? Do we have, or rather, are we having the necessary conversations, especially with young girls? When we were growing up, it was always taboo to talk about sexual intercourse, to talk about how to protect yourself as a young girl from child pregnancy. Why? Because it was perceived that you don't engage in sexual activity. But I think that kind of approach now does not work. We really need to face the emerging realities that young girls and boys are engaging in sexual activities rather at a very early age. So what is the role of the church in this? What is the role of the community leadership in these conversations? What is the role of the schools, the teachers in these conversations? These are the conversations that we should have even at a family level as parents. We should be brave enough to talk about abstaining, or to talk about, of course, this is very controversial, to talk about safe sex or sexual intercourse. Yes, admittedly, it's perceived that children are not engaging in sexual activities, but they are, because you'll find that some of these pregnancies are as a result of, teenagers coming together, mukomana mudiki nemusikana mudiki, vese vari two vobva vaitisana pamuviri. Handiti inyaya dzekuti every day we don't talk about it. Why? Because we having this kind of see no evil, hear no evil approach. But with the reality that's emerging, that kind of approach is not helping anyone. We need to face the reality as it is. I mean, as a social problem, as a social imperative. I think at a social level, that's what we need to do. And then coming to the legal issues, I think we do have a lot of work to do. We need a concerted approach. We need a multidimensional approach. we need to have an all stakeholder engagement, starting with the police, even where the perpetrators are arrested, and then going to the issue of the prosecution. How effective are the mechanisms in place